Welcome. My name is Thomas Bona. I'm a partner at Pillinger Miller Tarallo, and I'm the moderator for today's conference webinar series. Our conference webinar series today is a 2023 PMT legislative update, new laws you must know. And we've been doing our PMT SJU conference webinar series over 4 years now, and our goal has always been to provide useful information, ideas and concepts that impact our industry and discuss it with industry experts and thought leaders. We have a great panel today who are going to help us understand these laws, and I think you'll find some useful information here that you can immediately take home with you. I'd like to first thank St. John's, the Tobin College of Business, and the Greenberg School of Risk Management for their support of our conference webinar series. Both myself and PMT have deep ties to SJU, and so we're very happy to be partnering with St. John's on our conference webinar series. I'd like to thank Larry Pistel, who is the director for the Center for Executive Education, for helping us put this together. And I'd also like to thank Joe Levine and Rob Stewart from CC&G, which is PMT's branding and marketing partner, for helping us with the nuts and bolts to get our webinar together and going. For those who are not familiar, PMT is a regional insurance defense firm with offices in New York, New Jersey, Pennsylvania, and Connecticut. Our focus is very simple: results and value with swift, cost-effective resolution of cases. One of the ways that we provide extra value is by putting on webinars like we're doing today, giving webinars to companies, and serving as an information resource so that we can keep everyone up to date. So we're going to start first by asking our panelists to introduce themselves. Mark, would you start, please?
Hello, everybody. My name is Mark Pillinger. I am an executive partner at Pillinger Miller Tarallo. I have been practicing longer than I'm going to admit. I am on the board of the New York City Trial Lawyers, the New York State Academy of Trial Lawyers, and I have been lecturing on this and many other topics with my fellow members of this panel, and it is always a pleasure to have the give and take with this panel, as illustrative and illustrious as this one is.
Thanks, Mark. Neil Sambursky, would you please tell us a little bit about yourself?
Sure. Hi, everybody. Neil Sambursky. I'm the managing partner of PMT's Garden City office. I run the firm's insurance coverage practice. I also have a whole defense practice as well, but our coverage practice really covers the gamut of CGL, PL, and all other kinds of policies, both regionally and across the country. So pleasure talking to everybody today.
Thanks, Neil. Ken Krajewski, would you please tell us a little bit about yourself?
Good afternoon. My name is Ken Krajewski. I'm a partner with Pillinger Miller Tarallo. I am a member of the New York State Bar Association CPLR committee. I'm also a member of the technology section, and I am a former chair of the Torts Insurance and Compensation Law section of the New York State Bar Association. I frequently lecture on various different topics, but I right now very interested in artificial intelligence and how it affects our work as lawyers.
Thanks, Ken. John Tambasia, would you please tell us about your background?
And good afternoon. I'm a partner with Pillinger Miller Tarallo. I practice in New York, New Jersey, and Pennsylvania, trying cases in both state and federal court, usually transportation and catastrophic matters.
Thanks, John. Joe Donahue, would you please tell us about yourself?
Good afternoon, everyone. It's a pleasure to be here. My name is Joseph Donahue. I'm a partner at Block, O'Toole, and Murphy. We handle significant personal injury cases on behalf of plaintiffs. I myself have been practicing. I've been a trial lawyer now for going on 27 years. And this is my third time with this crew, and I appreciate being invited back. It's always a great experience.
Thanks, Joe. It's a pleasure, as always, to have you. Let me ask Judge John DeBlasi to please introduce himself and tell us a little bit about his background.
Thanks, Tom. Probably most of you know I'm a retired Supreme Court Justice, Ninth Judicial District. For the past 16 years, I've been a mediator and arbitrator, independently affiliated with NAM, National Arbitration and Mediation. My practice has really diversified over the years. I would say right now I'm doing 50% personal injury and 50% commercial and other areas of the law, such as employment, Child Victims Compensation Act, and cases such as that. And as always, Tom, it's a pleasure to be back this year.
Al, please, I
Save
apologize.
the best for last.
I didn't think I
Last
could
but-
be worse than last, but not least. I didn't think I could outdo that. All right, after 40 years in the insurance business, I'm an actuary by training. I joined the faculty at St. John's University. I currently serve on 3 insurance company boards, including chairing audit committees. So that's my background.
Thank you, as always. Thank you first, again, to all my panelists for taking the time to be part of this. We really enjoy and thank you for your input and for being a part of this. And I'm so glad that you're here, Al, because we have a lot of questions that will impact your expertise and what you can bring to the table. So thanks so much for being with us. We really appreciate it. Let's get started. So the first law we want to talk about is something which I think people have already heard about. I don't think I'm understating it to say that if it is signed into law, it will be a landmark piece of legislation in New York. It will dramatically change how damages are computed, evaluated in death cases, and who is available to get damages in death cases. We're very fortunate that we have Mark Pillinger as our panelist today. Mark is on the board of the New York State Academy of Trial Lawyers. He's been following this legislation for a couple of years. He's been following where it is, what's going on, and what is the latest with it. So let me first ask Mark. Mark, our current law has been in effect since 1847, and that's not a mistake, 1847. And I know New York likes to be considered on the cutting edge of legal and social trends and everything. And it's now coming time for a change in the way wrongful death cases are compensated in New York. Why now? What is bringing this about now, Mark?
Thanks, Tom. So wrongful death recoveries in New York is a creature of statute. And as Tom said, the law was passed in 1847. And I don't think that any practitioner, be they plaintiff or defendant, can take a position that the law does not need to be changed, because the law as currently constituted does not recognize the family structure as it now exists in our society. Why it is happening now, I have to get into a little politics here. We have a Democratic supermajority. They are primarily progressive, and therefore, and we have a, I don't want to use the term weakened governor, but certainly a new governor who did not have the power of Governor Cuomo, who was concerned about the breadth and scope of potential changes in the law. As, quite honestly, speaking for myself, I still am. Unfortunately, without editorializing, I feel that the pendulum never winds up in the middle on many things. So the bill, by way of a little bit of history, the initial bill was pocket vetoed by the governor. The new bill was passed by both the Senate and the House. The Senate passed it on June 6th, 2023, and sent it to the governor. The bill passed by large majorities in both the Assembly and the Senate. It has been a very long time since a democratically controlled legislature has overridden a veto of a Democratic governor. I think it's happened once or twice in the past. As of our board meeting of November 29th, and I checked today from the Academy, the governor has not signed this bill. She has about 102 to 200 bills sitting on her desk, and they are scrambling to deal with these issues before the close of the legislative session. The governor has deep concerns about the breadth and scope of this bill, and I would not be surprised if the bill is not vetoed yet again. The primary concern is the cost of the bill to hospitals, doctors, the possible effects on insurance premiums and business throughout the state.
All right, well, we'll go and unpack some of those in a second, but first let me ask Joe Donahue, our plaintiff's attorney. Joe, do you think this bill is the right bill for wrongful death damages in New York to make it more in line with what the other states have?
Thanks so much, Tom. And I do, and I think Mark said it best. This doesn't come from a plaintiff view or a defendant view. It really comes from a humanistic view. And what the proposed legislation is just trying to accomplish is recognizing the loss of those left behind, which has not been recognized up until now. I think it's long overdue. And if you look at it, I believe we're one of 2 states in the entire country that don't afford levels of damages for family members that are left behind. So I do think it is the right legislation. I think from a humanity viewpoint, it's giving recognition to the damages, the loss, the suffering of those left behind in tragic situations.
Okay, thanks. Mark, what are some of the changes? What are some of the key distinctions between the old law and the new law that we can immediately see the difference in a wrongful death case? Can you tell us about some of that?
Sure. So the new law, as proposed, and I want to emphasize that this could be, and I feel should be, the subject of negotiation between the governor and the legislature, but it would take effect immediately upon passage, apply to all claims or causes of action that accrue on or after July 1, 2018, regardless of when the action is filed. That means it would apply to matters involving a decedent who died on or after July 1, 2018. As a defendant, by the way, this creates tremendous problems for us when we're trying to figure out the layers of coverage between primary, excess, umbrella, because of the retroactive effect. So, as I said, from my point of view, I'm in favor of changing it. I would just like a little more clarification from the legislature as to what we're doing. So it extends the statute of limitations from 2 to 3 years from the date of death. It allows recovery for grief or anguish caused by the decedent's death, in addition to the existing measure of damages, it allows a jury to determine who comprises the decedent's quote, close family members entitled to damages based on specific circumstances relating to that person's relationship with the decedent. Close family member would be defined as the decedent's spousal or domestic partner, foster children, stepchildren, step-grandchildren, parents, grandparents, step-grandparents, step-step-grandparents, siblings, or any other person. This is the line that I'm not happy about. Or any other person standing in locus parentis to the decedent for the purposes of distributing damages.
Let me just
And-
stop for a second here. Neil, you try cases and you try cases nationwide on a lot of different things. Do you think this is like a black hole, this close family member definition? It's just going to be impossible to corral?
Well, for those of us who've handled cases in Texas, know when you've got a wrongful death case and you're mediating these cases, the entire family shows up. Next of kin, what we would call in this case, close family members. Does it create a black hole? I think it certainly can. And for those of us who handle cases around the country where you've got states that allow wrongful death recovery under an expanded definition of family, it's something you have to deal with and that a lot of us have dealt with in the past. And if it comes to play in New York, it'll be the same thing. You know, Joe will have the whole family there lined up at the table, all asking for their share of the pie. So it
All right,
could be,
thanks.
Tom, could be.
I appreciate it. Thanks. So Joe, let me ask you, think this is a little too broad? I mean, or do you think this gets it all right?
I don't think it's too broad. If you look at it, it doesn't just say close family members. I know there was a bill introduced in the previous session where there was a much broader definition of who could recover, and I think it was something to the effect of close family members. Here now we have an actual definition. So if I'm the decedent's, great uncle, I'm not going to show up and I can't claim to be his stepson. So I think the close family members actually, since the last piece of legislation that went before the governor, it's now been more narrowly defined as to who those individuals are. And it actually lists exactly who we're talking about. So I think it alleviates the concern. And I don't know Texas law. Neil alluded to it's a much broader definition. But if it is a much broader definition in New York under the current law that's been proposed, we won't have that.
Okay. John, you're familiar with New Jersey. How does New Jersey handle this issue? Do they have a statute similar to the new one that is being proposed in Grieving Families?
They do, but it is much more narrow with respect to who can recover. And there are also more limitations on the types of damages. I would say the interesting aspect of this is it puts people who are in loco parenti, for make the discussion quick, in a position to recover, which you don't have in New Jersey. So that's
Okay.
a very interesting question.
Thanks. Mark, tell us a little bit more about some of the key provisions and distinctions in this new law, aside from that expanded definition.
You're holding me tight here. So the law would amend to add additional categories of damages. And to give Joe an acknowledgement, they actually removed from the old law the language of recovering damages for disorders caused by such grief or anguish. And I cannot tell you how happy I am for that as a defendant. But this would allow damages for grief or anguish and the loss of love, society, protection, comfort, companionship, and consortium. It would, in my opinion, and we can, this would be a fun lecture for Mr. Donahue and myself to just sit there and go back and forth with each other on how broad this will wind up. But what frightens me, and with all due respect to the judge, we're going to have judges sitting in Supreme Court determining who is in locus parenti to the decedent. And now all of a sudden, the decedent's siblings will be potential claimants, whereas under the old law, they are not if the decedent had a wife, children, etc. And it's going to open up discovery to the point where we are going to be doing many, many more depositions of people who claim to be in locus parenti, because as a defendant, I am going to want to try to establish that they hadn't seen the decedent since their confirmation or bar or bat mitzvah. And this bill, I feel, will open up a wide range of awards based on subjective evaluations premised on emotional appeal rather than what I would term rational facts and arguments.
Okay, Mark, let me just ask Judge de Blasi. Judge, do you think this is going to be a workable law for the judiciary to be able to apply, or did you foresee challenges with this, with that definition?
I think it's workable, but I guess my perspective is unique at this point in time because I'm looking at it from the standpoint of being a mediator. And I think, and I bet you Joe would agree with this, one of the most difficult tasks that we have as mediators, and when we do speak to families, and I'm always available to do that, is explaining to them that at the present time that there's no value to the grief that they've suffered as a result of the loss of a loved one. In real time, in terms of mediating wrongful death cases at this point, what I'm seeing is consideration by defendants of the fact that this law may very well be enacted. And if the case does not come up for trial or it is settled prior to the law being enacted, they're opening themselves up to far greater exposure in terms of damages. In terms of the problems that I foresee with it is, let's say the day that this law is enacted, I have a mediation in a wrongful death case. Part of my job is to facilitate negotiations. Part of it, obviously, is to be evaluative and attempt to get the parties to reach an agreement as to what is an appropriate number. How do we do that? The day that this law goes into effect, I'm not going to have any guidance from any appellate court with respect to what a claim may be worth. And there were two cases in particular recently, and I think mediators get to the point, we're sort of like more humanistic because we're dealing with, the actual outcome and trying to get the parties to accept a resolution. And I think anybody on the plaintiff side knows it's very, very difficult with parties who've lost a spouse or a child to do that. But two cases in particular that really boggled my mind that I have mediated is one where you have a 19-year-old girl who's operating a motor vehicle. It's a crossover case, full liability, hit head on. She's going to college part-time, working part-time, contributing to the support of the family, is as close to her parents as any child could be, has the perfect background in terms of what she's done during the course of her life, has 4 younger siblings who are surviving her. And when I was looking at this case, I'm saying to myself, assuming that this is enacted and both the parents and the siblings, are able to recover damages, how are we ever going to calculate that? I mean, at some point, the appellate division or the appellate courts are going to have to weigh in and give us some guidance. A separate case that I've had involving a firefighter who was tragically killed in a fire in New York City, leaving a wife and 4 children. Again, incredibly compelling, as a mediator looking at this, the results in terms of the damage that this did to both families was just catastrophic and horrible. And what comes to my mind, I think this law has been long needed. I think it should be enacted, but as a practical consideration, what I've been looking at is how do you evaluate it? what's the suggestion that I would make in terms of compensating the survivors? Let's classify them as that with respect to damages. And I know in other states where I've mediated cases that do have these laws, that the damages awarded to a single parent can be extraordinary. I had one case in Illinois where the jury award was $16 million to a mother who lost a child in a drowning incident. So, my perspective really is wondering, once this law comes into effect, how are we going to mediate these cases? How are we going to place a value on them? And it's incredibly difficult.
Thanks, Judge. Joe, you share any of these concerns, or you think this will all kind of, in the general scheme of things, it will all get itself, in the right balance?
A lot was thrown at me there, so I want to kind of go through in order if I can remember it. Starting with what Mark was talking about in terms of the different types of damages of grief, and how we define those things. Him and I could probably sit down for a long time and agree and disagree on a lot of those things. But we have similar types of damages that are already in place in various cases. For instance, pain and suffering in the second component of that, loss of enjoyment of life. I guess Mark and I could sit down and talk about loss of enjoyment of life and what that means. But generally, I think we figure that out. And more importantly, juries figure that out. With respect to the other issues with respect to the value of cases. And yes, it gives some uncertainty on pending cases, and it opens up a whole new host of potential plaintiffs. But what we have in place or what I want to say really is, we don't want a law not to come into existence because at the outset, we're going to have to work out some things that have some gray areas, especially when the law is just. And then on top of that, what we have in terms of figuring out those damages is we have similar types of damages that we can look at. For instance, loss of parental guidance. And we can also we have juries that make decisions in terms of value. And even more importantly, if juries don't get it right, we have very, very bright appellate division justices that can set the mark where they think it should be. So while there's always new concerns with new laws, but I don't think that's a reason for it not to be enacted. And I think we can use other cases, other types of damages, precedent that exists to really establish and work out those gray areas, so everybody have a little bit more guidance when it comes to whether it be resolution through just settlement discussions, meeting in a mediation, or everybody evaluating the risk of what a jury may or may not do with a case.
Thanks, Joe. Let me ask Professor Beer. You've been in the inside of insurance companies for many, many years. You sit on boards. You're the Excel professor, Excel chair at St. John's. And so you have a very deep understanding of insurance company environments. With this new law, obviously damages will increase. Who's going to pay for this? Obviously policyholders will pay for this, but how will insurance companies factor this in? Where will the increases go? And are we just, the larger question is, which Judge de Blasi touched on, is this simply going to increase, again, the social inflation of damages in another way?
All right, so the answer is yes. So let me tear that apart. One of the most difficult parts of this, and again, I'm an actuary by training. I've been talking to claims professionals. Certainly the most knowledgeable group of experts are attending this particular session. And every one of them is saying it's subjective and very difficult to project what will happen. And yet insurance companies now have to come up with a specific number. So going forward, it'll be very difficult. Now, there are some precedents. Joe brings up a very interesting point. Alabama and New York are the only states that don't allow non-economic damages. You're correct there. One of the problems, however, is that many of those other states have caps, and New York does not have caps. So that type of balance is going to be very difficult to project what ultimately will happen. Number two, I just referred to prospectively. What I don't expect a lot of people to shed tears for the insurance industry, but keep in mind, if this law passes, every premium that was charged since 2018 is now inadequate. I mean, that premium was predicated on an entire different set of laws. So those particular issues regarding reserving, et cetera, I find it interesting. I think everyone should read the governor's original veto, her big issue was basically, it was kind of a ready, fire, aim argument of the legislation was passed without any evaluation of what the economic implications are. And one of her strong points on her veto was she's worried about what those implications are. And Tom, I think that relates to your question. Who ultimately is going to pay for this? Eventually, the insurance industry, hopefully remaining solvent, is just a pass-through mechanism. And those losses have to be passed on through premiums to the insureds. So many of you may be aware that there was an actuarial study, in fairness, on the original bill in 22, not this one. But the expectation was it would increase costs by $2.14 billion in New York. It would hit hardest medical malpractice. There was an argument made in that report that med mal premiums would increase 45%. So just to give you an idea of those orders of magnitude that they're thinking about, laying on top of a healthcare issue, Governor Hochul is very concerned about the ability of certainly taxpayers to absorb those kind of loss premium increases, but especially in today's economic environment. So there's a lot going on as far as noise is concerned. So I will certainly suggest that the insurance industry is spending time trying to anticipate this, but there are a lot of unknowns, as my colleagues have pointed out. So ultimately, I believe it's fair to say the costs have to be passed on to the taxpayers.
Thank you. Thanks, Professor. Mark, going back to the law itself, you've mentioned that there was concern with the law about, and Professor Beer mentions it too, about medical malpractice and healthcare. And I had read in somewhere that there was some discussion that perhaps there could be some carve out or some set aside to exempt, medical malpractice from the Grieving Families Act because of the effect that it might have on healthcare. And I then saw that the sponsor of the bill, I believe it's Assemblyman Hoylman Siegel, had said, no, he's not going to do that. He's not going to make a carve out. This bill has to go all the way, or we're going to duke it out. Are those true concerns there about medical malpractice?
So before I address that, I think Mr. Donahue raised a very important point for practitioners when we're speaking about this bill. My first boss, gentleman by the name of Salzetnik, used to say, you win or lose your case during jury selection. He kind of felt that everything after that was kind of superfluous. I don't know if I'd go that far, but as Joe pointed out, jury selection will become even more important under this legislation because, yes, you can always go to the appellate division, but if I'm a plaintiff's lawyer, I'd much rather go to the appellate division with a verdict of $16 million and then defend it or concede to negotiate it than me being the defendant and trying to tell, especially certain departments, that they should knock it down. In response to your question, Thomas, and I'm now going to get on my soapbox. Shocking for those who know me. As I said before, we need change. We need to acknowledge the life that people now live. And this is being recorded, so I can't even deny I said this. But we also need compromise. Remember at the beginning I said the pendulum never winds up in the middle? It is my understanding, and I could very well be wrong because I'm not in Albany, that people aren't talking. That the governor, the legislature, they're digging their heels in. It could be posturing. Who knows? There's very strong emotional opinions on both sides. But I feel that if we could sit and discuss a compromise dealing with med-mal, hospitals, certain other charitable institutions, that perhaps we would get a bill that we could all live with, even if we're not happy with it. I still feel that, with all due respect, the definition of who is a potential claimant creates issues that the Supreme Court judges are going to be the first line, and God help them, because I don't think the legislative history helps the judges very much on this issue. Eventually it will shake out. It always does. We're still trying to catch up from COVID and the effect it had on litigation, which is what we all do here. And to have this now thrown in on top of that, you know, it's gonna, I'm kind of glad that I'm not in my 30s anymore. Looking forward to dealing with this for the next 30 years. But yeah, I would hope that there would be rational discussion in the legislature with representatives of the health industry, the insurance industry, the plaintiffs' bar, to come up with a compromise. Contrary to what many of my brethren on the defense side feel, I actually find that many times plaintiffs' counsel can be reasonable, and that we can rationally.
Can you say that again, Mark?
We're being recorded.
Joe.
Just for me.
I'm on the record here. Look, all kidding aside, I'd much rather litigate against Block and O'Toole, which is one of the best plaintiffs, very dangerous, but they are practitioners in everyday life. They understand we all have families. They strongly advocate for their clients, and that is their obligation. But using the term in the generic sense, they are gentlemen. And the most important thing in our business is if somebody gives you their word on something, that you can then walk away and not wake up in the middle of the night wondering whether it's true or not. Unfortunately, and I know I'm going to be quiet, Tom, I promise, that is not necessarily is something that we can count on as either plaintiffs or defendants.
All right,
But
well, we have a couple of questions that we want to take. Well, let's see. There's 3 questions here. First one, what's the wrongful death bill number so we can track it to register it? And Ken has answered that. It's bill S74A. Well, actually, the new number
that's
is
wrong.
S6636, right?
Right.
Okay. And the other question was, does the bill provide a time or period when the close family members are interacting with the deceased? Or what about members of the family who are not talking or have fallen out from a regular relationship, such that are estranged family members now beneficiaries? Guys want to tackle that?
to me, the answer is very simple. No, the bill provides us no guidelines or how to narrow the field without discovery. I suspect if I was a plaintiff, I wouldn't want to junk up my case by putting 20 potential plaintiffs in there, all of whom, 10 of whom, would be generous, have a chance for minimal recovery and result in delaying their case 2 years, I defer to Mr. Donahue, with all the additional depositions and discovery and authorizations and, why take a good case with, it's a terrible thing to say, a good case in this, where you have infant children, a wife, close family members, parents who are actively involved, and then tack on a second cousin twice removed just for the fun of it. In keeping with what I said before, I am certain there will be many practitioners on the plaintiff's side who do just that.
Joe, let's get it from the horse's mouth. Joe, tell us how
Great
do you
point. And you
handle
know,
this?
I can't, obviously I can't speak for all plaintiffs' lawyers. I could just tell you how we go about doing our business. And what it comes down to is it comes down to credibility. And when you bring a claim and you make various claims, you have to have credibility. Because at the end of the day, the people that are going to be evaluating those claims, whether they be people like Mark and like Neil, or whether it be your claims adjusters or your claims people, and more importantly, and just as importantly, your jurors, they're all smart people. And if you bring claims that lack credibility, what that does is it then impacts the other claims that you have that are credible, and they make them even less credible. So Mark's exactly right. You need to bring credible claims, and the credibility of those claims are going to be hashed out during the discovery process when you take the depositions. And of course, you want to get your case through as quickly as possible, but you're never going to sacrifice quality for speed. So if you have to do more depositions and more discovery, that's fine. But the last thing you want to do is sit down at a deposition when you bring a claim for a family member, and it turns out that that family member hasn't spoken to the decedent in 30 years. They never had a relationship, because then what you're doing is you're losing credibility as the lawyer, you're losing credibility for the case, and you're losing credibility for the valid claims that you do have. And that's just the way we go about doing business.
Right, you see
Thanks,
that all
Joe.
the time in cases where a plaintiff's firm might assert a meaningless claim for either a plaintiff or someone close, like you might have here. It kind of can dilute your whole entire case.
100%.
Because
I
it
totally
becomes
agree, Neil.
it becomes our job to use your specious claim as a lever to challenge what might be your valid claims. So, that's the way I look at it.
And the last thing I'm going to do is give good lawyers at your firm the opportunity to do that, because I know exactly what you're going to do with those specious claims. You are going to absolutely annihilate the valid claims that we have.
Right.
You have to be careful.
Yeah.
Let me just ask Judge de Blasi for his little final comments on good claims and bad claims there with potential close family members.
Yeah, I actually am going to put out, I guess, a question to Neil, Joe, and Mark. Put them on the spot, so to speak, because the conversation is really talking about what happens when we get to trial, and what if there's an appeal. But if the law is enacted, what can I anticipate as a mediator? For example, Neil, you've probably been in states where the laws are similar to that of what's being proposed in the state of New York. So let's say take a simple fact pattern of parents. They have an only child who's 13 years old. The child is killed in an accident. It's full liability. In a state that was similar to New York, what would you anticipate the demand would be? And then, Joe, I'm going to put it on you. If you had that case in New York and this law is enacted, what type of demand would you put forth on that case? And I'm asking this because this is what I've been thinking about as a mediator. I want to get these cases settled. How is this going to evolve? And again, I'm a proponent of the law. Absolutely. I think it should be enacted. I think the delay, honestly, has been disturbing to me. So I'm a proponent of it, but I'm just trying to figure out how am I going to go about selling these cases? Neil, what's the history that you've had?
Well, all I can tell you is in the states where I've seen it, first of all, I always make sure I have good local counsel to make sure I can get an accurate evaluation of what these cases are worth. But when you're in some of these other states, when you've got claims with multifamily members, catastrophic law, if it's a wrongful death case, you got to also factor in, is there a conscious pain and suffering element? Mm-hmm. While Joe's firm, may issue some huge demands, what we see in some other states, I'll just say Texas again.
Sure.
The demands are astronomical, astronomical. We're not talking about 10 or 20 million. You can start, I have a client recently who the demand to them, I think the demand was $300 million in a fatality case. And in a lot of these other states, what you're dealing with, unlike New York, is potential punitive damages. I'm not talking about the coverage, but in a lot of these other states, that's a real aspect of things. So I'd love to give you a real quick soundbite for purposes of this discussion, but it's really kind of difficult, because I know I'm saying the obvious. It is so fact driven. And, when you're facing a case with numerous potential beneficiaries to an award and catastrophic damages, from our side, you've really got to do your homework and make sure every T is crossed and I is dotted, so that when you're looking at, the firm across the table with that $200 or $300 million demand, you have the ability to tell them why it's only maybe a $20 million case, in that particular thing. But it's always difficult. It's always difficult. We just had one I just had one in Philadelphia, catastrophic injury. One was, I'll tell you what, one was a death case, captured on video. It was horrific. Whatever we got out of that case, but the demand to us beforehand was tremendous. And people say you can never win summary judgment in Philadelphia County. Luckily we did. Right. But we had it, we had another one where it was just tremendous, and it's always difficult. I always tell people I'm not necessarily guided by a demand. I'm guided by what our evaluation is, and that's kind of the way we always look at it.
Okay. And
Thanks,
John,
Neil.
I'm putting you on the spot, and I would just say to everybody, I'm battling COVID right now, so at some point I'm going to check out.
Well, we
feel better.
Yeah,
we really
but
appreciate
I wanted to ask the question. I'm going to stay on as long as possible.
Okay.
This is a great
So
panel.
let's
Joe?
go.
Let's hear Joseph. What about one of you, Joseph?
Let's hear
Yeah, I'm
Joe.
not taking the bait, Judge. I agree with Neil.
No.
Well, to come up with an off the cuff, what kind of demand you'd make? Every case is different. You've got to evaluate the facts and circumstances of your case. And then with something so new like this, I think you're right. You'd have to look at similarly situated jurisdictions where you get similar types of verdicts, as well as appellate courts in other jurisdictions, to see what those are sustained at, to look at maybe different types of damages here in New York that are somewhat comparable. So you could have a reasonable idea of not only what a settlement value is, but a sustainable value. And, I've always taken the position that to make an out of the sky, pie in the sky demand, $300 million, if your case really has a value of 10, it doesn't do you any service. It doesn't do any service to your client, because all it does is it prevents the possibility of having a resolution, which, some very smart people that I know say we are in the resolution business. Right. And Jeff Miller is one of those people. So to me, it's all about really getting all the information you can to come up with something that's thoughtful, and as Neil said, reasonable, even for people from my firm.
So someone raised a good question, and that was, the law won't change the limits of liability. But what I would say, that's of course true, but of course the difference becomes, if you had a case that before the Grieving Families Act may have been worth $100,000, and you have $1 million policy, but the act might increase the recoverable damages to $500,000. Or if it was $1 million case and you've maybe got a $5 million excess, and all of a sudden it's a $2.5 million case. So it's a great point that limits don't change, but what does potentially change is the impact to your limits based upon a change in the law.
Good point.
And that retroactivity, which is what I mentioned before. I now have to go back to 2018 and try to figure out the layers of coverage that were in existence 5-6 years ago. as a defendant, I have enough trouble getting insurance information for an accident that happened in October of this year. And it's
Okay, so this has been a great discussion. I wish we had time to continue it a little longer. We can come back to it maybe if we have some extra time at the end. So the next law that we want to discuss is the artificial intelligence and the CPLR, which is a new law, which has, I believe taken effect already. But we are very fortunate because we have Ken Krajewski, who is on the New York State Bar Association Technology Committee, and he's been following this law for a while and is going to help us understand it because it's going to have fairly large implications for people who try civil cases and evidence in civil cases. So Ken, tell us, can you give us some background on this law? Tell us what it's about, what some of the key provisions are, and how it will affect trials.
Absolutely. It's very interesting because I think it opens a door to a realm of things that most of us are not familiar with. And it's going to open a door in the courtroom, certainly, that will create substantial issues relative to admissibility and evidence. Within the PowerPoint, I did put the key aspects of this bill, which will take effect on January 1st, 2024. And it is an amendment to Article 45, the Rules of Evidence in New York. And it essentially says that admissibility of evidence created or processed by artificial intelligence will be admitted based upon certain criteria. And the statute actually lists out the criteria. It's very unusual for a evidentiary statute in New York State to lay this out in such detail. But I think this is based upon a recognition that this is an aspect of our daily life and litigation that is going to need some substantial guidance. It is also modeled after proposed rules for the federal rules of civil procedure, which are still in committee. But basically, what we have here are 2 points. The first and the second being that artificial intelligence evidence may not be received in a civil proceeding unless the evidence is substantially supported by independent and admissible evidence, and the proponent establishes the reliability and accuracy of the specific use of the artificial intelligence in creating the evidence. And really, that's just a breakdown of New York's Fry rule. And so, that shouldn't be too difficult. But it's the second part that is going to be challenging for the practitioners out there, and that is artificial intelligence may not be received into evidence in a civil proceeding unless the proponent of the evidence establishes the reliability and accuracy of the specific use of the artificial intelligence in processing the evidence. And that's a pretty big mouthful. It's part 2 of the Fry rule, but it's when we're talking about artificial intelligence, it is something that is going to generate some substantial litigation, or at least that's my prediction and the prediction of other people in this. So let's talk first a little bit about what is artificial intelligence? What are we even talking about here? Well, a generally accepted definition is that artificial intelligence is a concept and category of technology that is powered by advanced mathematical models and data that can augment, replicate, or improve upon human cognitive tasks that otherwise require thinking beyond calculating. Wow, what does that mean? Okay, well, calculating is pretty simple. Calculating is two inputs always equal the same output. 2 + 2 = 4. That's calculation. But artificial intelligence goes beyond that, and that goes into thinking. Well, what's thinking? Thinking is where two inputs don't necessarily produce the same outputs. And so an example that has been used is if you put a box of cookies in your grocery cart, sometimes you might put a carton of milk in, and other times you might not. Well, that's thinking. What's the basis behind making the decision as to whether or not you can predict whether, when I go to Wegmans on my way home from work tonight and I buy a box of cookies, am I buying milk with it or not? And that requires thinking, and that's what artificial intelligence is intended to replace. So how does it work? It works on algorithms. We've all used that word. We've all heard that word. We all think we know what it means because, you know, the algorithms in our Facebook profile or our Instagram profile or our TikTok profile, the algorithms generate certain things. If using an example we just had here, if I like the Beatles, and on TikTok, I constantly click on Beatles songs, well, I'm going to get a lot more Beatles songs. So that is what artificial intelligence does. It produces new information from existing information that is not present. I didn't tell TikTok I liked the Beatles. But it is reasonably deductible from the existing information that it has. So now think about this in terms of proof at trial. How do you do this? Okay, how do you prove this at trial? And what are the challenges that are involved? And how are we going to deal with this as practitioners? Well, the idea is to broaden the lens, so to speak, of the human experience by providing intuitive insight that comes from mathematical processes that we can't possibly do in our lifetimes, but computers can do. But it comes with limitations. What are those limitations? And this is what, you know, a defense counsel is going to have to try to prove up at trial to keep plaintiffs' artificial intelligence information out of the case. Well, you have three different things that you can look at. Limitations can be, is the algorithm based upon human data that's inputted into the algorithm? In other words, what are the biases, if any, of the person who processed the data to put in the algorithm? There's also algorithm bias. That could be, what are the biases of the design of the algorithm? Is it just looking for classic rock, or is it looking for all kinds of music? That's going to make a difference as to what my TikTok profile pulls up. And another bias is how the machine itself, the computer program, learns. Is it, let's look at it this way. If you're looking, if you're on Instagram and you like dogs, so you're looking at lots of pictures of dogs that pop up in your Instagram feed, and somebody puts up a picture of a coyote or a wolf. Well, Is that going to show up if your interest is in dogs? I mean, they look a lot alike. They appear to be a lot alike. It's not that simple. It's how broadly does the algorithm learn to differentiate between genuses of the animal kingdom? So, these are where we're going to attack those kinds of biases, and that's how we're going to try to attack artificial intelligence from being admissible in court.
Can I ask you a
Thanks,
question, Ken?
Ken.
I apologize.
Ken.
Can I ask you a
Yeah,
question?
yeah.
Sure.
Because the more I listen to what you're saying, and I find it fascinating, I find it akin to, we're talking CPLR, so it's state court. It's
Yes.
really akin to making a Fry challenge, right? Is that what you anticipate?
That's
For those
exactly
who
what it
aren't familiar with New York practice, if we're in federal court, we're talking about Daubert, which is
Right.
the challenge to the admissibility of expert reports and expert discovery on a whole variety of reasons. But it sounds to me like, 4551 kind of frames this potential AI submission to a Fry challenge.
That's exactly what it is, Neil. That's exactly how the statute was designed, to create a pattern or a blueprint for for how to make it admissible, but what you need to do to challenge the admissibility of it.
And would there be any, because again, I haven't read this, so I'm listening to what you're saying and I find it fascinating. Is there any carve out in this portion of the CPLR to perhaps allow an expert deposition on these issues, or some way to obtain discovery of it, as opposed to just, the normal, New York is like the Wild West, for those who don't know, you don't get expert depositions except in very limited circumstances. So are we still in the Wild West when we're doing the Fry challenge on the AI under 4551?
Yes, we're still on the Fry challenge.
Okay.
Which means that we're looking whether the artificial intelligence evidence that's being proposed by the proponent is subject to generally accepted techniques, and if properly performed, generates results accepted as reliable within the scientific community. Okay, but herein lies the issue that the commentators are looking at. I actually looked at a series of manuals that various courts in various states have put out to train judges on how to deal with this. And here are some of the challenges that we're being faced. If you've got an expert that you're putting on relative to engineering, how to build a bridge or what have you. Well, in that set of circumstances, you need just the engineer, and he's going to tell you all the stresses and all the formulas that went into building the bridge. How do you do that with AI? Because you're looking at various layers. You need to authenticate the process by which the AI was created. In other words, was it generally accepted within the programming community that this program was designed and created in such a way that it is legitimate AI? Then
Ken, can I interrupt for a second, because you're touching on something that I want to get a little bit more thought on, which is, do you think the judiciary is going to be tech savvy enough to really apply this new law? A lot of people don't understand AI at all, and we're asking the courts really to do something that they've never done before. What does our panel feel about that? Joe?
This is Neil. Hold on. Sorry. I actually don't see it as a far leap from what courts have dealt with before, for the reason I mentioned earlier. You have lots of cases with highly scientific experts that are put up all the time. And that's the whole purpose if we're in state court to have a Fry challenge, and that's the whole purpose when you're in federal court to have a Daubert challenge. What I was thinking, Ken, and if we're, because AI is really coming to the forefront, what it will require probably from both sides in the case, certainly if I'm on, let's say, the defense side trying to challenge the admissibility of AI, I will probably need a software engineer, right? Some expert in coding who can follow and I use logic in quotation marks because it is a term of art in software development, right? So you'll need an expert who can follow the logic of the AI that's being proffered so that you can challenge its, I'm using integrity, but the integrity of the AI being proffered so you can challenge its admissibility, right?
Well, not only that, but also the ability to interpret the results.
Right.
I mean, some of it's very simple. Again, going back to my example, is a wolf a dog? I mean, most of us can figure that out. But when you're into a sophisticated a set of facts where you're using AI to generate, and I'll do a Mark Pillinger and give you a brief war story. I represented a skid steer loader company where a component part very similar to those they look like shock absorbers that are on your car that either hold up your hood or hold up your trunk. One of those failed and a person got hurt. And our task was to take the information that the engineering department of the manufacturer did and replicate it over millions of operations in order to determine what the failure rate of these particular pieces of equipment were. And so we had to explain not just what our piece of equipment was, for which we needed an expert engineer to talk about, but then we had to explain what our test procedure was, how our test procedure was built virtually, and then how to interpret the results of our virtual tests. It was 3 layers, 3 layers of experts on it in order to try to establish that.
And let me ask Joe Donahue a question. I want and throw it open to the whole panel as well, because we have to move along. I'd love to spend more time on all of this, but we do have some time constraints. Joe, do you think that juries will be able to weight the AI evidence properly, or do you think that's going to be perhaps confusing?
I don't think they're going to get much of a chance to, because I don't think it's going to come into evidence, quite frankly.
Okay.
First of all, I think in terms of usefulness, I think the usefulness of AI will be in very, very limited circumstances. In the run-of-the-mill cases that I handle, whether they be a labor law case, motor vehicle accidents, things like, I think the usefulness of AI is very, very limited. And I think what you're going to get is when you're in court and something as complex as this comes in terms of, admissibility or not, I think 9 times out of 10, if not more, they're going to be precluded. It's too complicated. The technology is hard to even understand for the lawyers, let alone the bench, for them to ask the jury to make a decision utilizing AI. I just think the usefulness is minute, and I think the complicated nature of it is going to just, the knee-jerk reaction is going to be precluded.
And
Okay,
we also really don't know
within the
That's the
sound
easy
discretion
answer.
of the trial court.
But we
That's
also
the
don't know
easy
what
answer.
form it's even going to take.
Right.
We're using the phrase AI right now. There's not going to be a robot coming in.
Right.
No.
We sort of deal with this in big, in catastrophic injury cases where you have computer modeling of accidents. And you have someone putting forth a computer model that they want to try and get into trial.
Which
and
most of the time doesn't come in.
Right, because
Right.
we have a hearing beforehand to challenge the modeling.
Right. And in this case,
Judge-
with AI actually making the decision, you can't cross-examine the thinker. So whether you have a Fry or Daubert, and you can put an expert on the stand to talk about how they reach that conclusion. Here, the conclusion, the decision is being reached by a computer. So I think the usefulness is going to be very limited, and it's not going to get into evidence.
Thanks, Joe. Judge de Blasi, you concur with with,
I
Joe?
agree with what was said insofar as, how this actually plays out in, the court system. I think where you're going to see this being used, at least from what I'm doing right now, is in the large commercial cases, where this could be relevant and useful. Commercial firms are going to start using this. Does that ever see the light of day in a courtroom? Probably not. That's my gut on it. However, I'm doing a lot of tri-panels in commercial cases, commercial arbitrations, and I think we're going to see it, in the context of commercial arbitrations. Now, whether the panels allow it, that's going to be something else entirely. Generally speaking, commercial arbitrations, in terms of the rules of evidence, operate under the federal rules unless the parties agree otherwise. But, thinking about this, if I were to project where I'm going to see it in my practice, that's probably where I'm going to see it.
Thanks, Judge. Professor Beer, did you have a comment you wanted to make? I thought I saw you open up there.
Just very, very quickly, every profession is dealing with exactly this question. So I just wanted to share, I think the reaction of this panel is as close to my opinion as I could get. I do definitely believe there's a lot of noise, but probably not a realistic threat. The only concern I would have, and Neil's analogy of expert witness is perfect, except that you all know there are expert witnesses and there are expert witnesses. There are people who are out there who may or may not have the depth. So one of the things you need to be concerned about is understanding what this AI threat is all about. And Ken basically gave you the first semester curriculum of a PhD program in statistical bias. It's I was just at believe it or not, an actuarial panel on AI the other day, and they brought up a perfect example of there's virtually 100% correlation between ice cream sales and deaths in swimming pools by drowning. Right? And the reason is warm weather brings both, but people confuse correlation with causation. So I apologize for being very academic there, but that's a classic example where I see AI could trip us all up if we're not careful.
You are absolutely right that correlation is not causation, and that is going to be the challenge for those opposing it. But on the other hand, if you think about the pattern jury instruction for a product liability case in New York, and that was the product reasonably safe for its use as designed, what else are you going to do except put on an expert witness to say, I ran this thing 100 million times. I couldn't actually do it because it would have taken 10 years to do it, but I put it through a computer program that simulated all the aspects of this, and this is what it spit out. It fails one time over 10 million tries. Is that reasonably safe or not?
Ken, thank you very much, and thank you, the panel. That's a really tremendous conversation. The last topic that we want to tackle today is proposed bad faith and unfair settlement practices act in New York. Now, we've talked about this before. This came up, it was voted on in the Assembly. It got over to the Senate, and the Senate insurance chairman apparently didn't like it and decided that it wouldn't go any further. There may be a new chairman of the Senate Insurance Committee, I'm told, and there's a new chairman of the Assembly Insurance Committee, David Weprin, who was one of the progressive members of the House. And so we very well may be seeing this again in 2024, maybe after the Grieving Families Act is dealt with. But we have very fortunate to have Neil Sambursky on our panel today. Neil heads our coverage practice, is very well versed on bad faith and extra policy litigation. Neil, can you tell us first, what's the current standard for bad faith in New York?
My first reaction is they're really, at this stage of the game, it's very difficult in New York to establish a bad faith case against an insurance company. Tom has the slide up of Pavia. I've litigated, bad faith cases involving failure to settle within limits. And it's a very fact-intensive inquiry. But as we have up on the slide, you really have to establish the gross disregard of the insured's interests. That's deliberate or reckless failure to place you on equal footing, blah, blah, blah. The fact that an insurance company may get a demand within limits doesn't mean you have to pay your limits or settle the case. Is it a questionable liability case? Are the damages questionable? There's a lot of factors to go into whether you have to accept a settlement demand. And, there's lots of cases after Pavia, and it's very rare that an insurance company, certainly in New York, that has been held liable for bad faith failure to settle. New York is different than other states. It's not like we're in Florida with the claims administration statute. You get a time limit demand, you have to worry. Or if we're in Texas dealing with Stowers or Washington State, New York has been a much more forgiving environment, or West Virginia, a much more forgiving environment. And what we don't want to be here today is Chicken Little, the sky is falling. This bill A85623B was introduced in 2019, the 2019-2020 legislative session. And it was not passed. Tom says it may go back in. If it is, trust me, we're following it, because the bill that was submitted was extremely onerous, created, some tremendous potential obligations on insurance companies, and, went much further than, Pavia certainly ever did. And it creates a private cause of action, about an insurance company failing, that refused or to delay payment of a claim. But it's much more extensive than that. And the real kicker is, if a policy holder establishes a violation of the statute, not only are there consequential damages, but the statute itself contemplates potential punitive damages against the insurance company, as the court may allow. And it talks about consequential damages. And as many of you may know, consequential damages are not ordinarily covered, but what they talk, and when I say covered, allowable as a recoverable damage, right? But what they put in this particular section, it says here, for purposes of this section, it shall be presumed that consequential damages were within the contemplation of the parties at the time of contracting, right? Because obviously an insurance policy is a contract, and consequential damages aren't generally permitted for breach of contract unless contemplated by the parties. So it's pretty onerous. As we have up here, policies to be disclosed. If that's the case, that's really not a far stretch from what we already have under the CPLR, certainly after the amendment of the Comprehensive Insurance Disclosure Act, which I've lectured on. Evaluate a claim within 6 months, allow 30 days to, there's a whole host of truly onerous provisions, which, as we sit here today, I really don't want to worry you all about, because this isn't law. This is not up for a vote right now, but we kind of wanted to just put it out there again. I know Tom has presented this before, just to kind of let you know, it hasn't been thrown in the garbage. It can be reinvigorated. So, as with so many things here, we stand vigil. We're monitoring the legislature to see if this moves through the government. And if it's ever passed, rest assured, we're gonna get to you all on it.
Thanks, Neil. I appreciate that. Let me just ask Al Beer from his perspective. Al, we've talked about this before, and once again, if when and as it ever passes, all the costs will be borne by policyholders, right?
Well, I guess I'm going to take a slightly different tack in that. What's the problem we're solving? Is the industry behaving so cavalierly and so carelessly? Or is this just another evidence of, we've got to get big corporate organizations to get in line? As I said before, I'd like to think that legislation around the world solves problems, and I don't see the problem that's here. I know that there may be bad cases, there's no doubt about that, but I don't see how a law like this will change the behavior of an insurance company.
Okay, thanks. Now, we did have a question which related, we have a couple of questions, and I'd like to take them, and make sure that we get answers to them. The first one is, and we were talking about the Grieving Families Act. Could the bill have a chilling effect on settlements if the parties must wait until the conclusion of the statute of limitations to determine whether there are any additional close family members who might assert a claim?
Yes. It just today, I got in a wrongful death case from a plaintiff's attorney who I am not familiar with, who pled the Grieving Families Act in the complaint, which I don't quite understand how you can do that since it's not the law. I'm being a little sarcastic here in case I didn't show it. But yeah, it could have a potential of having a chilling effect on settlement if I don't know that I'm settling with all potential claimants. But
Except what we would be doing, right, is if there was a case in suit and the statute of limitations hadn't expired, but we're in a position to try and resolve, obviously what we would be insisting on in any general release is a hold harmless from the party who we are paying, for whatever it's worth, that they have to defend, indemnify, and hold our clients harmless for any potential future, I'll just put it in quotes, close family member who may come out from the woodwork to try and pursue a suit. What does that do? I think if Joe is prosecuting a case and he knows we're going to insist on this, they're of course going to be hopefully doing their due diligence to bring out those people. But I agree with Mark, it could have a chilling effect, but we can't let it stop our resolution or potential resolution of cases and the protection that that we would insist upon, as we do in so many cases where there may be an undefined risk, is a hold harmless.
right. Or liens.
Yeah.
I'll go, Tom, if I may, I'll go even
Yes,
further.
please.
In New Jersey, we have some odd problems because of the cross state between PA, Delaware, and New York. In these instances, although it's not a Grieving Families Act problem, it's a matter of who tries to claim. The courts have held plenary hearings, and I've had several issues where there's been a question as to who has been able to settle or accept. We have had plenary hearings, and this may be, the way the statute is constructed, far more of a problem for the plaintiff's bar than they realize. And I know if I had a case presented to me where there were potential other claimants, I would not settle without a hearing right now.
Joe, do you want to add something?
Yeah, I think as a plaintiff, you couldn't even contemplate settlement until you did your due diligence,
right,
to ascertain if there's any other claimants that have a rightful claim under the statute as passed, and make a determination, if those claims can be brought. Otherwise, potentially committing malpractice, quite frankly.
And
You
don't forget,
have to ascertain that information and when viable, bring those claims to protect the rights of those individuals.
and one of the odd things in the litigation I've had that's parallel to this, I'm not going to go into the details, but it's similar. We've had these hearings in New Jersey. You would be surprised how many attorneys come out of the woodwork for the claimants. It's a very unusual situation. And Neil, you probably dealt with this too, because you do quite a bit of cross-border practice.
Well, what I'm thinking of is when you have a statute like this, you serve an interrogatory. I know New York, you can't get putting that aside for a second, you serve a very focused interrogatory on who are the potential, other close family members. These are all things that'll be, worked out and that we do deal with in other states. But it is problematic. And you're right, John. We do have hearings in other states about, who is entitled. It can create issues.
Yeah, as a
Let me
defendant,
get to
we
the-
have to worry. I'm just sorry, Tom. As a defendant, we have to worry about exhausting coverage, and then all of a sudden having second cousin twice removed filing their own lawsuit. So
Let me try and cover the last two questions because I do want to be fair to everybody who put questions in, and I'll read them both together and then we'll throw it open. Does AI coverage in the law 4551 cover data analytics methodologies or repeatable data evaluation methods utilizing sources from business intelligence, competitive intelligence, risk management, or decision analysis. And there's a second question, which is same topic. Does the law 4551 have a systematic error correction to overcome systematic error in algorithms for establishing a benchmark for proof at trial? I'll throw that open to everybody. Ken, you want to tackle that one since you're
Sure, sure.
guru on this?
The second question is easier to answer, and that would be yes. It does. It has as we discussed, a built-in opportunity for the opponent to the AI to be able to come in and say, no, this doesn't work the way you say it does, and here are the people who are going to say that. It's, as Neil said earlier, it is the Fry hearing procedure, and you get an opportunity outside the presence of the jury to cross-examine the witness that is trying to establish the AI and explain why it is that that they're wrong, or put on your own witness saying why it is they're wrong. The first question is a little bit more difficult to answer, but I would just say this: built into the statute, there is a provision that says that the AI is only admissible if it is substantially supported by other independent and admissible evidence, separate from and not derived from the artificial intelligence. So basically, you have to have a human being who's going to come in and testify to the foundation, why it is that the AI led to this result. This is the foundation for it. This is how it was developed, and all the AI did was take the calculations out 10 million times and explain what would happen in the future.
It sounds to me, Ken, like they're almost saying it's hearsay, and you need that proof you just discussed to eliminate really a hearsay concern. I make it by analogy.
Oh, you know, Neil, you're exactly on point. I didn't want to get into that, you know, because we're not talking to attorneys, but
Right.
That some of the commentators have talked exactly about that and saying that you can't challenge AI on a hearsay challenge because it's not a person who is testifying. So it can't be hearsay. It's something else. So the statute is designed exactly
Right.
to provide that avenue to attack it on a essentially hearsay basis.
Right. That's why I was saying by analogy, right? Because it's
Yes.
not here. It's not right. It's not an out of court statement by a declarant, but for all intents and purposes, it's the functional equivalent of it.
Yes, it's the
Yeah.
machine equivalent of it.
Yes. Yes.
Well, everyone, we'd love to go further and keep on discussing these new pieces of legislation. We've had a really terrific discussion. I want to thank all my panelists for their time and you know, being part of this and their insights. I want to thank, of course, St. John's Greenberg School of Risk Management, Tobin College of Business for their help. And again, if anyone has any questions, please feel free to contact us. We're also very, very happy to serve as an information resource for you. And I want to thank everyone for once again being part of our conference webinar series. And that includes our repeat people, Joe and John DeBlasi and John Tambasia and Mark and Professor Beer. Thank you so much for all your insight and your analysis. So
For having me.
thank you very much.
Happy holidays, everybody.
Happy holidays, everybody, and
Happy
Mark
holidays.
too.
Happy holidays.
Thank you.
Be well.
Yep. Bye-bye. Thanks, everyone. Bye-bye.